Mr. Lords, I was just, I had almost finished ground one, but I just wanted to say one or two more words about it before getting more into ground two. We say, in essence, the sort of vice of ground two is also shown in ground one, where there is a sort of an over-formulaic approach to the importance of the multifactorial comparison. So I don't mean to say that it's unimportant, but that it is ultimately just a comparison of the visual, oral, and conceptual, and inserting the word highly before the words similar for the visual and oral wouldn't necessarily change the result. In other words, the judge may regard, and this judge here did regard, an overarching point when it comes to the overall assessment to be descriptiveness. And that clearly is a point of importance in the judgment. We say none of the grounds of appeal really engage with that because it doesn't disappear just because you've got use. And that's the point of the Steele Co. Case that I'll come back to. But there's no principle that just because you establish two high similarities, you win two out of the three, visual, oral, and conceptual. And there's no principle equally that if you establish some similarity in the conceptual and some on the visual and oral, that you win either. These are just factors that get put into the final analysis. So that's why we say one has to keep a bit of perspective on these grounds, certainly grounds 1 and 2, because they really are taking issue with the multifactorial comparison. Now, when it comes to ground 2, I just wanted to make sure that the court had in mind the target or the challenge for my learned friend, which is that this must be established to be rationally insupportable under the Volpe case law. So this isn't a question of an error of approach, that sort of thing. This is purely a finding of fact that is said to be rationally insupportable. And it's secondly, an attack on the comparison. Ground 2 is an attack only on the comparison. It is not a ground that goes to likelihood of confusion. It is then leveraged into other grounds, I accept that. But the first basis, the sine qua non, is there was a flawed comparison to the rationally insupportable standard. And we say, seen in those terms, the judge's finding was not only not rationally insupportable, but it was absolutely right. The judge looked at the mark VETSURE and he looked at the mark PETSURE. And he asked himself, what do those mean? Now, they are not...
Where does he answer that question? Well, he says the marks are for different concepts. Where does he articulate what the concepts are and how they're different?
So, Lord, the first point in answer to that is these are not dictionary words. They're portmanteau invented terms. They don't have a meaning as such. So it's not a question of picking them up and saying, oh, that's what they mean. The judge gave an indication of what they sort of conveyed, and he did that perfectly well. And as was put by Lord Justice Phillips, he considered them as wholes as well. He didn't just simply consider their independent elements, but these are portmanteau terms that he had to interpret. And so if I take that part of the judgment, he looked at, if we pick it up from, I think it probably comes in at 83. No, sorry, 82. Core bundle, tab 6, page 86. The mark VETSURE will be perceived by the average consumer as made up of two well-known words, VETSURE. VET is descriptive of veterinary services, and SURE will be understood to be described insurance services. Absolutely nothing wrong with that. That is, in my submission, not only one that he was entitled to reach, but that is plainly the correct interpretation of a portmanteau term. Portmanteau term is Brexit or Nescafe or whatever it might be, comprising two words that are joined together and communicate some other thing, or sometimes a combination of things. But they don't have a precise meaning. They're not dictionary words. So quite apart from the fact that my learned friend, we say, is wrong as a matter of principle to suggest that you look at the goods and services, actually looking at them in the way we say they should be looked at, the judge got it absolutely right. Then when it came to PETSURE, it's true that his reasoning is a little more attenuated. But he's already said in 83, vet and pet mean different things. So what he's saying there is, sure is the common element, that means insure, and vet and pet mean different things. Now, I wanted to pick up on the word different here.
Just before you do,
Sorry.
you say they mean different things.
Yes.
So VETSURE presumably is taken to mean something to do with insurance services relating to vets.
Relating to vets, exactly.
Now, that could potentially mean insurance services provided to vets, but it could just as well, couldn't it, mean insurance covering the cost of going to the vet?
Yes. And he's taken the view that it's essentially vague. It's essentially vague. It's sort of multivalent. It points in a few different directions. That's what he's
PETSURE, on the same basis, has to be insurance services relating to pets.
Yes, yeah.
And that obviously encompasses the cost of going to the vet to get medical attention for your pet.
And many other things besides.
Well, how many other things besides?
Well, you see, in this case, the claimant, in fact, their smallest line of business is pet insurance. They're principally in the business of supplying pharmaceuticals to vets. And secondly, in the business of providing pet health plans, which are not insurance at all.
Yeah, sorry, I think we're on PETSURE at the moment.
Oh, sorry, PETSURE, yes.
PETSURE is about providing insurance relating to pets.
Yes, on its face, that's right. And I think the judge says that. He says it's got to do with its insurance, and he says that pet means something different from vet.
Now, pet and vet obviously do mean different things taken on their own. Yeah. But as you say, you look at the whole. So one is insurance services relating to pets, which obviously encompasses going to the vet. And the other is insurance services relating to vets, which could mean insurance for vets, but is equally, at least, capable of referring to the cost of going to the vet. And if it's about the cost of going to the vet, it's exactly the same concept as insuring your pet.
Yeah, I mean, if the later mark was farmsure or zoosure, the examples we've given, then yes, with sufficient reasoning, you could find some overlap. Vets, large animal practice, they might be serving farms and so on, or there might be zoologists or whatever. The point is, this is a very superficial, necessarily so, and somewhat abstract exercise at the beginning of the analysis, where the judge just has to point out what he thinks it is. And the fact that the earlier term might fall in a class indicated by the later term as well, that doesn't mean that the judge has to sit there and say, oh, well, I find that there's some similarity. He's simply responding to the meanings of the words as they are written on the page. And we say that was absolutely, if that has to be called rationally insupportable to simply state the meaning. My learned friend began his submissions with what I consider to be quite a big concession. He began by saying, pet and vet are different things, but they are related. And in my submission, that is exactly correct. So we accept that they are related, but that's not the question here. The judge wasn't asking himself whether they were related or not. He was simply saying what they mean, as they are written on the page. That's all he's required to do. And in my submission, that is what he did, and he did it adequately. If one thinks about how you perform the visual analysis, it's exactly the same. You don't sort of think, oh, that's a picture of a pear, and a pear might end up next to the apples in the supermarket, and someone might buy them in response, No, you just say, that's a pear, that's an apple. That's all you're doing at this stage.
And I'm sure in the course of all that, you said, well, the judge needed to say what the concepts were.
Yeah.
Coming back to my Lord's point.
Yeah.
Does he?
Well, we say that is informed by the fact that these are not real words. They're made up fancy terms. So they're used for trademarks, they're portmanteaus. They don't have a concrete meaning. So the judge simply has to grapple.
So how can they have different concepts if there's no meaning?
I'm sorry, no, I didn't mean to suggest they have no meaning, but what I mean to suggest is that their meaning is vague because they're made up terms. So they will communicate the sum of their parts, and that's exactly what the judge did. The judge said...
So I'm still struggling to understand what the answer to my question is. It might be worth coming back to the question I asked, which hasn't yet been answered. The judge says in terms, paragraph 84, line 4, the marks are for different concepts.
Yes.
What are the different concepts?
Well, he says the sure element is the same, but the PET and VET elements convey different concepts. Or to put it another way, not the same concept.
What I understand what he's saying is that VETSURE is you insure veterinary services, i.e. the cost of veterinary services, and PETSURE, you insure your pet. And it's a bit like you could have car insurance, which insures your cost against loss, theft, or damage. Or you could have a service plan.
Yes.
Which insures you against garage bills.
Yes.
But car insurance and a service plan are fundamentally different concepts, even though they both relate to cars.
Yes. I mean,
that's what I understand what he's saying.
Fundamentally different, or one could say perhaps related or in substitution for each other and have some connection.
But at heart, what he's saying is one of them insures veterinary services, one of them insures a pet. And that's my understanding of his distinction. Whether that is sustainable or not, or correct, may be different. But I don't think it's too hard to divine what he's saying is the difference in the concept.
And that is why, my lord, we say it can't be said to be rationally insupportable.
I know my lord has said it, but where is this explained?
Well, he doesn't. I mean, the detail of it is not explained, but we say it's in 82, perhaps 82, and then beginning of 83. The words vet and pet mean different things, and the average consumer will, perceiving the marks as a whole, understand that. They're not conceptually similar. Each refers to a different descriptive concept, and they can be distinguished. So essentially what he's saying is they have a meaning, but they're quite narrow in scope.
What I understand what he says, there is a degree of implication, this is for sure. But what he says in 82 is you take vet and sure, and the combination of the two is a combination of the two, i.e. insure veterinary services.
Yes. No doubt he's considering them as a whole.
Pet means various things. Now, taking what he said in 82, he's there saying that means pet insurance. And he's saying, as I understand it, that is conceptually different to vet insurance.
That's exactly how we read it too. The only way you get to my learned friend's position that's in his grounds of appeal, which is that they mean the same, but actually it isn't clear whether my learned friend is trying to submit that they mean identical things, because the moment he moves away from identicality, it's difficult to see how his argument can succeed, because he must be saying they're identical because they identify the same goods and services, or the same services. We say that's illegitimate for the reasons I gave just before the short adjournment. Now is not the time to be looking at the goods and services, and that's maybe a doctrinal point. There's potentially a wider point as to why that's not a good idea. If one thinks about it, as a descriptive mark, I apply for a descriptive word for services that are pretty much what they say on the tin. So I've got a descriptive mark for a descriptive service. And someone else comes along with a descriptive mark, and I've got a better case because the conceptual analysis is carried out by reference to the goods and services. We say that's getting it backwards. Normally, conceptual considerations are discounted as a result of descriptiveness, and that's in the Daniel Alexander decision that my own friend skipped over this morning. but I'll show you that, because it must be right that when you have a mark that is descriptive of the goods and services, that's a factor against you on the scope of protection when it comes to likelihood of confusion. So, but that comes in later. You don't get to have an advantage on that when it comes to the comparison of the marks. And all of this is really just going to say that you look at the marks as they're written on the page, and you respond to them almost intuitively without too much thought. And was the judge's analysis so wrong that it can be said to be rational and supportable? We say not.
Can I just test it one more way?
Yes, of course.
They're different concepts, we're told. So take the case of a consumer who wants cover in case his vet falls ill and he has to go to the vet. His pet falls ill and he has to go to the vet, and he doesn't want to have to pay the bill, he wants an insurer to cover it. Now, which of the descriptions would cover that?
I mean, I don't want to suggest that the mark VETSURE cannot be interpreted as being a reference to insurance for sick pet animals. That would be rationally insupportable of me, apart from being rather silly. The thing is, it isn't. That's not what this exercise is about. He's picked a meaning. He's picked a meaning from the available meanings, and he has said one is talking about veterinary services in some vague way. It may be as detailed as has been suggested, but that's not what he says. He says they're vet services, and one relates to pet. One says PETSURE, pet insurance. So that's what it comes down to. And when looked at through the sort of prism of rationally insupportable, for terms that don't actually have meanings, they have no concrete meaning. They are portmanteau terms that are intended to convey something. We say it's quite a strong thing to say that it's rationally insupportable. Yes. I mean, so vet insurance, I think, was put this morning that it might cover the death or theft of pets, and certainly some policies do. And actually puts me in mind of an example. If someone had applied for pet theft, that's what the mark is, pet theft, and the other one is VETSURE. Well, it's true, vet theft is part of pet insurance, but that's not what you're doing at this stage. You're not going into that much detail. If you have to think about the degree to which these things are related, that is going too far, we would suggest.
Can I ask you, describe this as a finding of fact, but it's really an evaluation.
Yes, it's an evaluation. So we defend it on two bases. Normally I would be saying that's a classic, even if he's wrong about it, it's no reason to disturb the decision because it's just simply one of the facts in the mix. And we say it would make no difference if he had found some. I think my learned friend contends for some conceptual similarity. He can't contend for identity. But because it's just one of the many factors, and actually we say completely, probably the least important of the factors that weighed on the judge's mind, if you still have that passage of the judgment open, he moves very swiftly on to the sort of likelihood of confusion factors, which are descriptive nature. And in fact, this is based upon evidence because there was evidence in the case that there were a plethora of other companies that use the word pet and insurance in their names, but not only in their names, but also that, of course, is the name of the product. It's called pet insurance. So even VETSURE will describe themselves when they are providing pet insurance as saying, we provide pet insurance. So there's a swirl of descriptive use around these two names. And against that, the judge holds, in line with, we say, very clearly established authority, that descriptive marks generally have a very small scope of protection. Consumers learn to tell them apart. It also means, incidentally, that consumers will mix them up sometimes, but that's only because they're descriptive. It's not because they think what is the other. I've got a pet insurance. I can't remember which one it was. It was a year ago. I took it out, so I call the wrong company. Was it that one? Might have been. Might be Tesco that they think they've got. It's not the name that's causing the confusion, and it's also not confusion in the sense of required by trademark law, which is essentially thinking one entity is the other, or linked in the course of trade in some way. So that is... Sorry. Oh yes, I should say it. Yes. Sorry, I didn't finish that submission off. It is both a finding of... It's an evaluative factor when the judge is finding similarity or not, but it's also a finding of fact that is challenged directly on the rationally insupportable basis. And that's my learned friend's skeleton, not mine, that said that it's rationally insupportable. So the other points I wanted to show you on this were the Appellant pair case. If I could just return to that. That was my authority. And I think it's probably worth looking. It's, I think, the leading analysis of, and binding analysis of, how to approach conceptual comparison. And I had a bit more of the case to look at before the passage relied upon by my learned friend. So you've seen the marks in that case.
So what's the reference?
I apologise. Authorities Bundle 1, tab 6. And it's page... So the section starts in 507, page 507, paragraph 55. This was a debate between whether there was low or high conceptual similarity, and the debate, if I could sort of summarise it, was between a position on the part of the earlier right holder, Apple, saying they're both fruits. They both compete in the marketplace. They sometimes are used, bought in substitution for each other, and therefore there's high similarity. And the General Court disagreed with that, and it was knocked out by way of reasoned order before it got to the ECJ. But broadly speaking, that is the position. I think my learned friend tried to distinguish it on its facts. It's not relied upon on its facts. I mean, these are device marks for a start, so the different considerations apply. But the basic position is you don't look more broadly at this stage. Now, if I can just show you the parts that...
Can I just ask you about this? You make the point quite rightly with device marks, and therefore it's a bit different.
Yeah.
So what's the proposition of law which you say that this case is authority for?
There are a few. I need to show you them. So the first one...
Why don't you tell me the proposition of law first?
First, yes.
And then we'll look at the authority to see if it supports that proposition.
The first proposition is that you do not look for whether two signs might be members of the same class in commerce or in industry or in use in order to assess their conceptual meaning. So, in other words, you do not blur the sorts of considerations that would arise when comparing goods and services when it comes to marks. That's essentially it. Because that is a different question, and it leads to unintended consequences.
Why is the case not simply authority for the proposition that an apple is not a pear?
Well, it's doubtless that as well.
Most consumers have no difficulty in distinguishing between apples and pears.
And we would say our case is authority for the proposition that a vet is not a pet. It's as simple as that, if it's put at that level. What you don't do is stand back and analyse the situation. Think, well, that must be something to do with pet insurance. Vets provide pet services, and so on and so on. Sure, that must mean insurance. In fact, the judge was rather too kind. Sure doesn't necessarily always mean insurance. Because there was lots of evidence of uses of sure as a suffix, and they weren't all insurance. Some of them were, safekeeping and various other things that you might associate. Securities things, yeah. So it was not necessarily all one way in that regard, but it's just a simple, intuitive response. And once you've got that, I just want to show you the passages which I rely. So there was also a discussion, because my learned friend mentioned the Sabel and Puma case as somehow supporting his position. The Sabel and Puma case is sort of the landmark judgment in trademarks. It's the big daddy case, the first one that really decided how you approach marks of likelihood of confusion and so on. And it was two bounding felines. One was a cheetah and one was a puma, but they were, I think, rough. One was outstretched and one was crouching, I think, from memory. And there was a discussion as to the extent to which marks which are conceptually similar but are drawn differently, so they can be told apart, can be held to be confusingly similar. And of course, all these cases turn on their own facts. But the key point in that case, we say, is that you don't get conceptual similarity merely by occupying a sort of similar space commercially, so to speak. We say that it's got to be something along the lines of, it's got to be understood, what does that sign signify? Is that message the same? And it's not only a question of whether it's said to be different or not. When people use the word different, they often just mean not the same. And we say the judge sort of meant that here as well. He didn't really say they're unrelated or they could have nothing to do with each other. He just said they're different concepts, and they are different. That doesn't mean that they're highly dissimilar, like the words motor oil and VETSURE would be. It just simply means that they're not the same concept. So, if I could just show you the passage just before the sidelined passage. Do you see on page 510, paragraph 72. This is all in the section on conceptual comparison. So 170 of the bundle, and then paragraph 72. Next, it should be borne in mind, according to the case law, the comparison of conflicting marks must be based on the overall impression given by them by reference to the intrinsic qualities of those marks. Conceptual similarity arises from the fact that both marks use images with a similar semantic content. Semantic content simply means meaning, and in relation to word marks simply means what do those elements mean, and that's exactly what the judge did. Now, those considerations counter the taking into account of factors such as those mentioned in para 32 of the contested decision, which are not based on the perception of the semantic content of the images. I won't turn to that for the moment, it's not relevant, I don't think, but which are distant from the actual depiction of them. The protection which is granted to an earlier figurative mark does not apply in the absence of commonalities with the depiction of the mark cited in opposition to the general category of phenomena that it depicts. The Board of Appeal was therefore wrong to take the view that the marks at issue could be regarded as being conceptually similar on the sole ground that the fruits which they depicted shared several characteristics in real life. In my submission, that reads onto this case. It is illegitimate to take into account the fact that, and these were words rather than devices, but that they signified something that in real life could be offering the same service. Thirdly, in any event, even assuming despite the lack of commonalities, other factors can also be taken into account, it must be held that the considerations set out by the Board of Appeal have at most only a very limited influence on the overall impression. That's a finding of fact. Then we get to the passage that's sidelined, and I think my learned friend showed you that this morning. But this is one of a number of cases where parties tried to say, as part of the comparison, you've got to take account of descriptiveness. Or as part of the comparison, you've got to take account of my huge reputation, because I'm Apple and I'm very well known, and therefore more marks are going to be considered visually similar to mine. And all of that is fine when it comes to the likelihood of confusion, but not as a matter of pure comparison. And that, in my submission, is fatal to the appeal, because my learned friend seeks to bring it in as rationally insupportable and only as a starting point, as part of the comparison exercise. And that's the part that he's focusing on. Now, it's true that the judge then goes on very swiftly to consider the broader questions that he's required to consider, likelihood of confusion and degree of descriptiveness and so on. And it's perfectly legitimate for these points to come in then, but they were not attacked on that basis. The judgment was attacked on the comparison basis. So, I mean, you will have seen the examples we've put in our skeleton. If the later mark were farm shore or zoo shore and so on, all the same points would apply. It would be said, well, that's in the context of providing those services descriptive, and therefore there's similarity. We say, you would have to draw the line at that. The reality is, they're not happy with the evaluation that the judge carried out. There was no discussion this morning of the appellate principle that applies in these sorts of cases. And my Lord Justice Arnold will be very familiar with this. But essentially, you've got to show an error of principle, and then when it comes to the sort of findings of fact, you've got to show they're rationally insupportable. And we say this appeal is miles from that. Oh, I wanted to just correct something I think that my Lord Justice Arnold said this morning. Conceptual counteraction, I don't think that was quite how it was put. Conceptual counteraction is slightly different. We weren't saying it was clear and distinct enough to avoid confusion, the differences between them. That's a sort of separate category of conceptual difference. And we don't think we need to as well. We were simply saying that the conceptual analysis was neutral. There wasn't conceptual similarity.
Right. And how does that square with the judge's finding that the concepts are different? Because if you're not supporting that...
Well, no, we support that they're different. We support that they're different. What I mean is counteraction.
Well, you've just said the concepts are neutral, so which is it?
Well, so this does not... We support the finding that there was no conceptual similarity because we say that the judge was right in his approach. We don't, however, say that that's counteracting the visual and oral similarity. That wasn't the judge's analysis. The judge's analysis was descriptiveness is the overarching consideration here. It was that was the problem. Imagine if they were descriptive of two completely different things, that would still apply. So we didn't need to say, the conceptual counteraction, my Lord, have in mind those cases, is it VETSURE and SIR and these other cases, where there was said to be a high degree of visual similarity, and the meaning was so different to the average consumer once they spotted the difference that would lead away and it would counteract. The judge didn't find that. You have disavowed conceptual counteraction, and that's fine. That's a very clear stance. And to take your phrase a moment ago, you said the concepts were neutral. So on that basis, would you accept that the correct way to analyse this case is that it's a case of visual and oral similarity, and contextually speaking, it's neutral, and so there's nothing to counteract the visual and oral similarity? That's right. The marks had a, we say, vague meaning, but a descriptive meaning. The judge found that they meant different things, so I live with that. The point is that when it comes to descriptive marks, those differences made a big difference. And that's the real overarching reasoning given by the judge throughout the case.
This is why I'm struggling, because that seems to be an argument of conceptual counteraction, and yet that's precisely what you're disavowing.
The law of conceptual counteraction, my Lord, requires marks to have a clear, one of the marks to have a clear and distinct and different meaning from the other.
Well,
and
indeed.
Doesn't apply to two portmanteaus that sort of mean vaguely a number of things.
Can I, in that context, put one sentence to you? The judge says the marks are for different concepts, and that indicates the absence of a likelihood of confusion.
Yeah.
That sounds like counteraction.
Well, It is a factor. It is a factor. It's not what one would call counteraction. And he doesn't use those words. It's not, I would submit that it's not, that's not the key part of the decision. It's not the part that's doing the work. What's doing the work is that they're descriptive. It would apply even if they were somewhat similar. That's actually the better way of testing it. Because if he regards them both as being related in some way to the field of pet insurance, that's fine. Because the descriptiveness problem that the judge has identified still is a problem for the claimant. It still means that people learn to tell the difference. It still means there's a lot of noise in the signal when it comes to confusion. And it still means that ultimately it has a very, very narrow scope. So that's why I say that it doesn't, I mean, it may not matter because he doesn't call it counteraction. In my submission, it's not the overarching consideration. But it wasn't argued on that basis. So let me move forward to the next. Right. So the next point that came up, I think, under this ground was touched upon was the indirect basis of confusion. And I don't know how hard that's pressed because my learned friend didn't have the benefit of being at trial. He for that reason, probably is unaware of how it was argued. But it was not put on the basis that's now being put. And the basis that's now being put not only would require evidence, but it's nonsensical. If I could just explain that. The way it was put at trial, the indirect, first of all, just to introduce the point briefly from Lords, direct confusion versus indirect confusion. The idea is with direct, you can't tell them apart. You simply mistake them, one for the other. Indirect, you spot the difference, but you think, oh, that's its brand extension, or it's something to do with Tesco because it's called Tesco 32 or something. Right? So the example's given in the case. I think my Lords picked up on the point quite quickly that this doesn't have the character of a brand extension or anything of that nature. And so it was always a bit strange to argue this. But the way it was put was shown to, you were shown my opposite was closing skeleton in the supplemental bundle. And I think that is a typo in 171. So it's in supplemental tab 11, page 204. But certainly my recollection of the hearing was that they were putting their case on the basis that it was a sort of network brand, because it's a network of vets. It's not like normal insurance, VETSURE. It's, well, it's not insurance at all to a large extent, but it's, to the extent it's insurance, it's administered differently. It's managed by the vets, and you've got to be a veterinary practice that's part of it, and indeed the principal of the company is a former vet, still practicing vet, I believe. And so that is, it was said that if you see 171, C relies on the fact that a key part of its business model is the VETSURE network. It's constituted of veterinary practices across the entirety of the UK, and so on. And it was suggested that PETSURE might indicate some other aspect of that, or membership of that. The way it's put on appeal, my submission, is a bit different. It is said that it could indicate a pet health plan. I think that's the principal way it's put. It could indicate anything, of course, and any passing argument will do for anyone relying on indirect confusion. But so it's a somewhat speculative basis. But we say that the idea that it indicated a pet health plan is pretty nonsensical because pet health plans are not insurance for a start. They're paying forward, a bit like your service, the example that Michael gave in relation to the servicing of vehicles.
That would normally be considered a form of insurance.
It is a sort of self-insurance or something.
Probably underwritten by insurers as well.
I'm not sure about that. It might be. But we say anyway, it doesn't really make much sense for it to be under a different mark. And indeed, it is under their own mark. why would they use a mark such as this? But the other point is, we could have cross-examined and explored this. It wasn't put on this basis at all, and so therefore shouldn't really be coming in at this stage. Yeah. We did. Okay. Yes, I think you better. Is it in the closing argument? I spoke out of turn. I should mention that now because before we go much further. Apparently, in our closing skeleton, we did actually refer to conceptual counteraction after all that. So, an example of perhaps going back and reading your closing skeleton would be a good idea.
Right. So can I be clear? Yeah. So in fact, you did argue conceptual counteraction at trial, but you're no longer relying on it. Is that the position?
No. I think what I wanted to say was I'd misremembered that we actually put it in those terms. And what I say now is the judge, as my Lord Justice Newey put it, does sort of hint at something that looks a bit like conceptual counteraction. But if you look at the case law on conceptual counteraction, it's arguably not falling within it because it must have a clear and distinct meaning that points away.
Well, indeed, that's why I thought you weren't putting the argument in this court.
Well, I rely on the words used by the judge. So I say...
I'm sorry, I'm now completely confused, Mr. Malich. Can you give me a yes or no answer? In this court, are you arguing conceptual counteraction or not?
In the form put by the judge, I am. So in other words, that was a factor that's not helpful to the claimant succeeding in infringement. It militates against it, to that extent, yes. But what I don't want to do, my lord, this is the concern I have, is I put a finding into the judgment that isn't there, based on case law that the judge doesn't cite, and then for it to be said, well, the judge was wrong. That's my difficulty.
It might be helpful to look at the way you put it in your closing submissions below, and then we'll understand how it was put.
So, subparagraph 9, the rather grand name for the case law.
Where are we?
Sorry, supplemental bundle, tab 12, page 242. And then this little subparagraph 9. So,
my lords, to save time later, it might help if you were also taken to page 272 to subparagraph 69F.
Yeah, that's, I'm grateful for my own friend, yes. They mean different things. I don't think we disagree with that. The question is, it's more a question of trying to respond to the point that's being said about whether it's legitimate to look into the marketplace and find a meaning that's similar. And that's what the claimant wants. The appellant says you must look into whether they are related things in relation to those specific services. And if you do so, there's only one answer. And we say no, you don't. It's illegitimate to look at that widely. And in any event, if you look at the words as you should do, they're different. And so to that extent, conceptual counteraction, it probably comes in at the stage of comparison, to be fair, rather than as a stage that comes in on likelihood of confusion, because it's about the significance of the conceptual difference. So if it's put in those terms, I stand by what I've said in skeleton, both those passages. So now the next question is reputation, and whether there's anything in this point about the hierarchy of reputation. Now, for that, my learned friend is authority-free. He says, if you've got a reputation, you must have an enhanced distinctiveness for the purposes of 5.2. My Lords may wish to just a very brief primer on this, which is that you are entitled to extended protection under Section 5.3, Section 10.3, if you establish a reputation. And there's case law on what you need to establish. One can imagine it's fairly fluid in terms of the factors that you can take into account, the evidence and so on. There's no set threshold, it depends on the case. There's a judgment by my Lord Lord Justice Arnold, Red Bull I believe it is, it's not in the bundle, which suggests that it is not a particularly onerous requirement. Now, that's not to say that it's easy, but it's not difficult to establish for many parties. And we say the reason for that is because it's really hard to establish the damage and harm that you've got to under the provision. So you should not think that just because you've satisfied reputation, that you automatically get any kind of use question decided in your favour when it comes to other branches of the same law of trademarks. Because all of these questions we've said in our skeleton are very different and they depend on what you are asking. So if, for example, under Section 5.3.10.3, you need to establish tarnishment, you need to establish, it's actually very easy to establish a link, doesn't have to show confusion, but you have to establish either tarnishment, free riding, or dilution. And these are notoriously difficult to establish. Do you then read across into the likelihood of confusion the fact that you have established a reputation? In many cases, I'm sure that is right. In many cases, where a party has amply crossed the line in terms of reputation, they will also have an enhanced distinctive character, which the case law says they get a sort of wider penumbra of a monopoly. But equally, it's easy to see that they shouldn't, because in a likelihood of confusion case, what you're saying is it's not just simply qualification for a likelihood of confusion, as it is in reputation cases or 10.3 cases. This is giving you a broader scope and saying more marks will be confusingly similar with yours because you're well known. So there's equally, we say, rational arguments to suggest that either they're just completely different or even that...
I assume you accept the proposition that more distinctive trademarks get a greater scope of protection.
Yes.
Than less distinctive ones.
Absolutely, yes, must do.
You may be aware, I've just given a judgment of that subject. I mean, it's not new. This goes back to Saville, but it is kind of well established.
It is well established and cannot be challenged. But the point is, if you've got a case of a mark where they've managed to squeak home on reputation, that's what happened in this case. This is not a big business. They weren't listed in the main industry guide, even listed. So, but they had done enough to qualify. This is really the important point. They'd done enough to qualify for the extended protection, to be in the game, so to speak, to be able to have the right to try and establish dilution, tarnishment, or free riding. Nothing more than that. And they didn't. But, of course, when it comes to the sort of case you're talking about, my Lord Justice Arnold, the point is you're giving an extra penumbra of protection over confusion, over cases where you just have to show confusion, whether direct or indirect. And so in some senses, I would suggest that's the highest standard, that's the highest threshold. But I don't think my learned friend took you to any case law that clearly establishes the proposition one way or another. And we would say there's no way that the judge can be held to have been in error in holding that this mark had a reputation, modest but sufficient for the purposes of 10.3, but not sufficient for the purposes of capturing all marks that are even vaguely similar. And the reason for that, of course, was twofold. First, that there were other companies with VET in their name. There were plenty of other companies with PET in their name, and there were other companies, although not in pet insurance, with SURE as a suffix. A plethora of companies again. And that evidence was something that was uncomfortable for the claimant, but it was a fact. It was a reality. And that's when we get into the case law and the position identified by Mr. David Kitchen QC, as he then was. In the Steel Co case, my learned friend took you to the passage. I don't know if I need to quickly just remind you what it says. Tab 3 of Authorities Bundle 1. And there was a sort of separate dispute about what it takes to, do you need to be a household name brand to get this extra penumbra of protection? But I wanted to just, page 31, and if you just look at the first 4 lines, or 5 lines, the global assessment of the likelihood of confusion must be based on all the circumstances. These include an assessment of the distinctive character of the earlier mark. Where a mark has been used on a significant scale, that distinctiveness will depend on a combination of its inherent meaning and inherent nature and its factual distinctiveness. That's important. The point does not disappear simply because you've used. And in fact...
So you're going to take us to the place where the judge makes a finding as to the inherent distinctive character of this trademark and as to its inquired distinctive character.
I'm going to say that the judge did make a finding about how this mark was doing in the marketplace, and that's its acquired distinctiveness, and he held that it was not so much acquired distinctiveness, but he did hold that it didn't benefit from enhanced distinctive character. It didn't have a high distinctive character. So I do say yes, he did that, I'll point to that. And as far as its inherent distinctiveness, well, that's the passage where he was interpreting the mark. So just to show you the principle here, when the mark has been used on a significant scale, its descriptiveness doesn't fall away, is what this is saying. And a few lines later, as observed recently by Jacob LJ in Reed Executive, this may be particularly important in the case of marks which contain an element descriptive of the goods or services. In the case of marks which are descriptive, the average consumer will expect others to use similar descriptive marks and thus be alert for details which would differentiate one mark from the other. And this is well established in the case law, and it applies...
To be sure, but you need to read the next sentence
as
well.
It may cease to be such an important consideration, but it all must depend on the circumstances. And in my submission, that's exactly what the judge did. He looked at the circumstances. He looked at the track record of the mark in the marketplace, of this mark surrounded by, it wasn't just the descriptiveness of the claimant's mark, it's the descriptiveness of the defendant's mark as well, which had a role to play here. Because, of course...
I don't understand that submission. We are concerned here with the distinctive character of the trademark. What's the sign got to do with it at all?
The sign is one of these other signs that's out there with PET or insurance.
Because we are assessing infringement as at the moment that use starts.
Understood. But at that moment, there were, well, first of all, every company used the word PET and insurance to describe their product, more or less. And maybe I'm exaggerating, but almost all used that as the name of their product. There were the biggest players used the word...
we seem to be shooting off in all kinds of different directions, Mr. Malinich. You're addressing ground 3,
yes,
which is about the distinctive character of the trademark. Can
yes,
we please focus on the distinctive character of the trademark? As you well know, there are 2 aspects to it. Its inherent distinctive character and its acquired distinctive character.
Yes. So if you take
You're going to show me where the judge made findings.
Yes.
As those 2 elements.
So the core finding, the inherent distinctive finding, was in core bundle, the passages we were looking at on the conceptual comparison. VETSURE will be perceived as 2 well-known words, vet and vet and insurance. So that's a distinctiveness. That's an inherent distinctiveness finding. Then what happens in the marketplace is at 110. Now, first of all, these grounds of appeal are somewhat fluid, but this was put on the basis that we were alleging there was no distinctiveness, or the judge had found there was no distinctiveness. That's not true. The judge just didn't find that there was enhanced distinctive character. You can see from 110. So it had a relatively small market share, and it had this descriptive element. It had some modest press.
So how do you square the last sentence of 110 with 93? Because at the moment they seem to me to be in direct conflict.
Yeah, so the last sentence is talking about the positive or favourable reputation. It's not talking about the degree of reputation there. It's talking about the reviews and so on. Yeah, this is talking about, there was quite a lot of evidence at trial about how many Trustpilot stars you had and so on. But there's no doubt that he found that there was a reputation for the purposes of 10.3. Indeed, that's one of the grounds of appeal. 93 is the required reputation, but the strength of the mark is not high. Well, that's important. We say, and this is what you meant, well, I'm going to submit, in Red Bull, when you said that it's not a particularly onerous requirement. You reach the standard relatively easily. The degree of your protection is then informed by how far you've exceeded it. So, but actually getting sufficient use for the purposes of reputation, it was a rational finding for the judge to have reached. It can't be said to have automatically followed that they had an enhanced distinctive character. That's the only point that matters here. Do they have an enhanced distinctive character automatically as a result of reputation? And we say that's just not the law. And on the facts of the case, the judge was entitled to reach the view. I should say my learned friend, my learned junior, Miss Akins, will be dealing with the instances of purported confusion. I just wanted to just make sure So this ground, I should say, was put, I'm reading out ground 3 of the ground of appeal. The judge was wrong to hold that VETSURE it would be understood as descriptive to the exclusion of distinctiveness. Well, that's not what the judge held. The judge did not hold that it had no distinctiveness. He just held that it didn't have a high distinctive character. And I wanted to also draw, on this point, there is a fundamental contradiction in the approach of the appellant when it comes to conceptual similarity and the overall assessment. What do I mean by that? Well, when it comes to the conceptual similarity, it contends for descriptiveness. It contends for descriptiveness in its mark. Indeed, it says ours is descriptive as well. But it says they both mean pet insurance. But when it comes to the overall assessment, it doesn't want you to think about the descriptiveness anymore. It should disappear from that part of the analysis. It doesn't accept that they're descriptive. Indeed, it challenges on this point. It says it's highly distinctive as a result of use. We say that's exactly backwards because distinctiveness doesn't come into the position at the stage of comparison. And I've showed you a case, but also that's a matter of principle. And then it does come in as part of the overall assessment and must come in. That's the real role for it. And indeed, that's exactly what the judge did in the ensuing passages, 83, 84, 85.
Sorry, I've got myself confused. I think this is just because I haven't been listening carefully enough. So it doesn't come in at the point of comparison.
Correct.
But it comes into the overall assessment.
Because at the overall assessment, everything comes in. The degree of similarity of the goods, the distinctiveness, any conceptual counteraction, the nature of the average consumer, all of those come in at that point. And so it very much comes in then. The degree of distinctiveness is fundamental to the overall analysis. But it doesn't come in at the stage of conceptual comparison, no.
Yes, I see.
That's the point. indirect confusion. Just a moment. I wanted to see if how much I'm leaving to my own friend. The passing off case. It's ground 8, so I'll deal with it different now, and then a friend can make some submissions on 14. The alleged error here is that the judge failed to provide adequate reasons because he held that there would be no misrepresentation. In the light of his previous paragraph of his decision, it is quite clear what his reasoning is. But in any event, the passing off claim was narrower than the trademark claim. It was always going to be less favourable for the claimant because it would bring into the... It talks about the actual customers of the claimant, but the actual customers of the claimant and the way that it administered its business and...
I don't understand this argument on either side. I mean, surely passing off stands or falls with 10-2 in this case.
Yes. That's our first submission. And if anything, it's worse because it's the specific way of trade of the claimant, which was quite distinct. It didn't go onto the comparison sites. It advertised in veterinary journals and that sort of thing. It's a very different business. There's never going to be a good scenario, a more favourable scenario from a learned friend to focus on passing off. But broadly, that's the position. I think those are my submissions. Mr. Yes, of course.
So sorry, you've covered so far grounds 1 to 4.
I have. I've gone to 8 as well.
Yes, I see. 1 to 4 plus 8.
1 to 4. He's doing 14.
Yes,
8.
that's right.
And I don't think any of... Well, I've sort of tried to cover it. So 9 is also the test for passing off.
Yes.
10 is the reasons for dismissing the claim under section 10.2. Lack of adequate reasoning for finding there was no likelihood of confusion. I mean, in my submission, the judge gave ample reasoning for that. His central finding was these are descriptive marks with a narrow scope of protection, and therefore the case doesn't help. But a lot of these grounds are also dependent on my learned friend's ground 2.
So just trying to get an overall picture. No one disputes that the marks are visually and orally similar. In terms of conceptual similarity or dissimilarity, is not something you're attaching great weight to, at least, in terms of the ultimate assessment of likelihood of confusion.
The true significance of the similarity or dissimilarity of the conceptual comparison is that they are descriptive. That's the true import of it. And that was the judge's finding. So it would apply whether they were similarly descriptive or differently descriptive. As it happens, the judge held that they were differently descriptive, but not a great deal turns on it because ultimately, and the claimants keep very quiet about this, they were descriptive. And its whole argument must be that they were descriptive to the same degree because they were the same conceptually. And therefore, it can't, we say, get home because waiting for it on the likelihood of confusion is this problem of distinctiveness. And that is where that's where the whole case really turned. Does that?
Yes, I see. Mr. Akins.
My lords, it falls to me to address you on ground 14, by which the appellant alleges that the judge erred in his assessment of the evidence. And I'll also make some specific submissions on the 8 instances that my learned friend took you to earlier today. Before I address your lordships on that, it's important to note that at trial, the claimant downplayed the significance of this evidence, said in opening that the evidence was a bit of a sideshow, and its primary case in its written closing was that the conclusion for the judge was a straightforward one, that there was a likelihood of confusion, and that was unaffected by any of the arguments over the subsequent evidence of confusion. So that puts it in context. Then, as far as the applicable legal principles are concerned, when one's considering evidence of this type, none of those are in dispute. My learned friend said expressly earlier today that those principles are as set out by my Lord Justice Arnold in the Little and Tesco case, and focused in particular on paragraph 120, which is one of the paragraphs that we quoted in our respondent skeleton. However, my learned friend now suggests that the judge did not apply those uncontroversial principles. And he says that he didn't do that in two respects. First, he looked at things quantitatively, and second, that he erred in looking at the evidence only as to whether it was genuine confusion, and not as a means of testing the propositions that he had identified earlier in his judgment in matters relating to the likelihood of confusion. In my submission, and our overall positive case on this ground, is that the judge applied the right principles in terms of the overall approach. The judge carefully looked at each piece of evidence relied on by the claimant and considered the submissions that each party made on them before coming to a conclusion which was open to him, given the limitations of the evidence, the caution with which it should be approached, and the fact that no individual had come to the court to give evidence that they were confused. And it follows from that that there was no evidence before the court as to what the individual in question had in mind other than the contents of the documents themselves. And that goes to both to whether they were confused and also as to why they weren't confused, which is what my learned friend focused on. Now there is one potential exception to that, which my learned friend took you to earlier today, and that was where the caller had said, "It's the shore that got me going." And so to that extent there is some insight into what was going on in the individual's head when they thought that they had made a mistake. Now I'll come on to that when we look at that particular example. But while I'm here, I say that supports our case because they have specifically identified the shore element. So not the whole mark, the shore element, as what led them to make the mistake. And it was common ground. In fact, it was the evidence of the claimant's own principal witness that shore would be understood descriptively as indicating insurance. So that is a purely descriptive element of the two marks that caused the mistake to happen. And that supports the judge's conclusion that the reason why individuals were making the mistakes that we see in these documents is that the marks are descriptive. So the first point, the first way in which my learned friend says that the judge didn't follow the established principles was that he approached things in a quantitative way. My submission, that's just simply not the case. You can see that from the judgment itself. He has identified one instance where he said that the relevant person was confused. He doesn't say that one instance is not sufficient.
Well, what do you say about paragraph 170? It does appear there was confusion in a small number of instances, but I conclude from the evidence overall there was no likelihood of confusion. That looks jolly like a quantitative approach, doesn't it?
Well, he's noting that there was one instance in which he found that there was confusion. That was the last one, that was PG, the 16th of the defendant's case. He's taken that into account. He's not saying that that doesn't reach the threshold, the quantitative threshold for a finding of likelihood of confusion. He's saying that that has not persuaded him overall, looking at the evidence overall, and he's having regard to the sea of evidence that he was presented with in this case. That was not sufficient by itself to lead him to the conclusion that there was a likelihood of confusion, and that's consistent with other authorities where evidence has been found of genuine confusion. but the court has still come to the conclusion that there was no likelihood of confusion. It's not applying a quantitative test here. He's simply registering the fact that he has found that there is genuine confusion in one case, but that's not sufficient for the conclusion that the claimant asked him to make. And then secondly, the second way in which the learned friend says the judge did not apply the applicable principles is that he says that the judge should have looked at the evidence, not simply as to whether it indicated genuine confusion or not. By genuine confusion, I mean confusing one undertaking for the other, or thinking that they were connected in the course of trade. In my submission, that is not what he was required to do. It's not spelt out in the test code that for every piece of evidence that you look at, you need to test every proposition that you have identified previously in your reasoning as a fact-finding tribunal, and say, what does this tell me about this proposition? What does it tell me about that proposition? He's looked at each individual instance, and he's spent a substantial portion, about a third of the judgment, dealing with these instances, and he has made a factual finding as to whether that constitutes confusion or not, or what else is going on here. And that, in my submission, is following the guidance in the authorities to the letter. I go further than that. So even if he had looked at it, there is nothing about these instances that could justify the inference that a different type of mistake was likely, so different from the type of mistake that he has identified and made a fact find about in these instances.
What type of mistake do you say he found?
Depends on the instance. And so that's why I was going to...
Because it might be said, and I think Mr. Paramus did say, that people who mistake a sign for a mark are by definition confused.
Even my learned friend accepts that not all of these instances are instances of confusion in the relevant sense.
No, but he says that what they demonstrate is a propensity for confusion.
Yes, but in that case, that is not what's happening. The relevant confusion is not happening in that instance. And what I say that does, in answer to your Lordship's question, we have a number of instances before the court where people have made mistakes. And so, as the judge himself said, these instances have come to...
What I have with the judge's analysis is he keeps on saying people have made mistakes without identifying the nature of the mistake that he says they've made. And I'm asking if you can... the judge said what the judge said, and it's not your job to fill the lacunae in his judgment, but if you can shed any light on the question, I would be interested in the answer.
My Lord, take the simple example of the post on social media by the event company, Events, which posted and said that we've just done a stand for PETSURE vet insurance rather than VETSURE pet insurance. We have some insight as to what the mistake was going on. And that's the mental bundle. There was an update to this bundle, and I hope that the update has made it into your Lordship's bundles. And it's the last page, it should be on page 346 at the end.
I have it anyway.
It's a text message exchange.
So that's where we should be going to, 346.
Yes, please.
Yep.
Well, in fact,
Sorry, what is this relating to?
let's first go to the actual mistake itself. So that's at page 309 behind tab 13 of the supplement. This is the social media post that I was just talking about. Yeah. By Events. You see that the second sentence below is one that is called "Just this week at London Vet Show for PETSURE vet insurance." And then the text message is between VETSURE and Events.
Sorry, between
Between VETSURE.
VETSURE.
So VETSURE is on the left. It is on the right, and MBART events are on the left, the grey coloured. And so you'll see that there are some messages from MBART events. And then VETSURE says, hey, I just noticed on LinkedIn you wrote PETSURE vet insurance, face. Would you be able to change it? Catch up soon. And then MBART events responds, good morning, all changed, sorry about that, got the P and D in the wrong places. So in my submission, that's clear from that. There's a typo. It's a simple typographic error.
So the thesis is that it should have said VETSURE pet insurance.
Exactly. That is the VETSURE's.
Indeed, the display shows pet insurance.
Yes.
On the picture.
VETSURE pet insurance. Yeah.
So your point is that this doesn't have PETSURE in mind at all.
Exactly, my lord. It's a simple typographical error. It's made more likely by the fact that the error makes sense grammatically and semantically as English words. But that is because these are all descriptive words and they are descriptive marks. So that's one example, my lord, of the type of mistake that is being made here. Now I was going to go quickly through the others that my learned friend took you to. I should first just have a little bit of a gripe that this is the first time that this exercise is being done by the claimant, by the appellant in this case. It wasn't done at trial. The judge was left with the documents themselves and some short written submissions by each of the parties.
When you say a gripe, is that a gripe directed at one side, or is it just the nature of the problem?
It is a gripe directed at the other side, my lord.
Because
this is the evidence that they're relying on. And so
the submission is that they were wrong to put their submissions in writing? What's wrong with written submissions?
My lord, today, that this court has been taken to the individual instances in oral submissions, and submissions have been being made on those specific instances. At trial, what the judge was asked to do was go away and read the documents and consider the written submissions that were made. In actual fact, when you go to the claimant's, it's Annex 2, to their closing submissions, which is in the supplemental bundle, tab 11, page 213. This is what was said by the claimant on each of the individual instances of confusion. So this is what the judge was left to go away with. And in my submission on this, there aren't actually any submissions by the claimant as to what is going on.
So just so I understand, was it that the claimant ran out of time in their submissions? If so, is the suggestion that that was their fault for misallocating their time, or what? How is it that this was not addressed orally?
My lord, this was a case in the shorter trials.
But it still had 4 days.
4 days? What were you doing for 4 days?
My lord, it is up to the claimant in a trial to allocate the time as they see fit. This is the evidence that they were relying on then. It is the evidence that they are relying on now. And it's for them to make the submissions on it, to make time to make submissions on them.
But what's wrong with what they've done here? They've pulled out relevant quotes. They say these are instances of confusion. What's wrong with that?
My lord, the point that I'm making is that today is the first time that the claimant, the appellant, has made specific submissions as to what in fact is going on in these cases. Didn't have evidence from any of the individuals concerned. The court didn't hear from that, so you don't have that insight into what is causing.
That's a different point. I mean, you make the point, which is a perfectly valid point. There's no live oral evidence. Fine. And the judge makes the point himself as well. But this is a different complaint, and I'm still struggling to understand it. I mean, I agree with you that it's remarkable that the matter wasn't dealt with in oral submissions. But on the other hand, what would the oral submissions have consisted of other than reading out what's in the annex?
My lord, what my learned friend has submitted today is that what is going on in specific instances is that they are not making a conceptual distinction. And
just so I'm clear, if I look, say, at pages 223, 224, 225, 226, those will have come in for the first time in the closing submissions. The rest of it was there in the opening submissions, presumably. Sorry, my lord needs the bits in red. Yes. That's right. So if we take the bulk of this annex, it was there from the start. It was there from the opening skeleton. From the opening skeleton. And as a result, in response, the defendants made their written submissions in their Schedule 3 yes,
to their closing submissions, which is also in the supplemental bundle and the tab.
Yes.
Well, page 291.
Yes.
But those were made without, as I say, the benefit of the type of submission that my learned friend has made today.
Yeah.
So, I've taken, Your Lordship, I've dealt with one of the instances. There were 7 others that Your Lordships were taken to today. So again, if I can ask, perhaps, can you have the judgment open from paragraph 120 onwards. So that's the core bundle, tab 6, page 92. And then the supplemental bundle. From tab 13, page 300. The first instance was RM, I'll use the initials to describe the individual concerned. The first instance was RM calling VETSURE in regards to renewal of an existing policy. Her policy was with VETSURE, so she correctly called VETSURE. And it's accepted that she wasn't in fact confused. She just said she was just checking who she was calling.
Well, let's look at that a little more closely, because at 301, we see that the reason why she was calling was because she had an email from PETSURE.
My lord, in my submission, that's not the reason why she called. The reason why she called was that she was checking when her insurance policy with VETSURE would renew. It may be the reason why she has said, can I just check that you are definitely VETSURE, not PETSURE? But it's not the reason why she called VETSURE in the first place.
Well, why does she say, and I thought, oh gosh, so I'll look for VETSURE?
I'll look for VETSURE, not PETSURE, VETSURE.
Well, indeed.
So that's because she's identifying correctly the insurer that she's calling to check when her insurance policy will renew.
But she's made a connection. And what's the explanation for the connection?
Because both marks are descriptive.
I see.
That is the reason in most cases. In other cases, it doesn't go even as far as that.
Do you say, I mean, if you mistakenly get an email from a car insurer that is not your car insurer, nothing, with no mix-up in the names, that's perfectly capable of jogging your memory that you need to do something about your car insurance.
Absolutely. Yeah. You may not remember who your insurance is with. In fact, I would say that's incredibly likely that you don't remember who your car insurance is with. And you may contact that insurer because they're the last people who put a name of insurer in front of you. That doesn't mean that you think that insurer is the same as undertaking or a connected undertaking to your insurer. So, but going back to my lord's point, we don't know why she's saying this. This was the individual who served a witness statement, but it was pulled on the morning of the trial because she wasn't willing to turn up to court and give evidence. And that is the difficulty, and that is why endorsement.
Yeah, well, there's always a problem with that because you're dependent upon the goodwill of members of the public to come to court, and why on earth should they? But then, even if they did come to court, you're asking them to try and reconstruct in their mind the events of a year beforehand. And why does their reconstruction necessarily help you that much anyway?
Well, this is precisely our submission, that this is all not very helpful.
Yeah,
and that is why
you were reinforcing the point you made earlier about the absence of live evidence. And I see the force of that so far as it goes. But what I'm questioning is how actually relevant would the live evidence have been anyway? I mean, the beauty of this case is its transcripts. And I very, very rarely, in my entire career, encountered evidence of confusion that is actually, or supposed evidence of confusion in this case, that's in a transcript. And so therefore, trying to ask people to reconstruct a year or more later what they said and why, here we've got the record of what they said.
No, but
and anything that the witness came to court to say a year later would necessarily have been reconstruction.
But we don't have the why. And the principle is that this evidence is probative, it's relevant, because it gives the court insight as to what the individual concerned was thinking at the time, what was going on in their mind. Because that's what...
So you would accept that we make what we can of the transcript?
You make what you can, but that is not a lot. That's what I'm saying. It's even less when you don't have someone coming to court saying, this is why I did this, or this is what was going through my mind at the time. Because you can't tell that from the transcript. But that is what this is all about. It's all about what is going through the mind of the individual when they are confronted with the sign, and do they think it's the proprietor, the trademark, or do they think that they're connected? That is what we're talking about here, and that's what this evidence has to actually go to and help the court with. So my learned friend says, well, the judge didn't look at this and take a view, attest his propositions by this transcript. My submission, that's not what he's required to do by the principles and the authorities. And it would be pure speculation to do that based on this transcript. I should say that my learned friend rightly pointed to paragraphs 121 and 122 of the judgment and said that they can't relate to this instance. And that's absolutely right. And so,
I didn't say that.
Well, 121.
And what else is the judge talking about in 122? This example, if he's not talking about RM, what is he talking about?
He's talking about the example in 121. So 121 is not talking about 120.
What?
Because Miss Edwards was not challenged. Miss Edwards, Katie Edwards.
Sorry, I'm baffled. I mean, you may be right, but that's not what it appears to say. 121, he says Miss Edwards was challenged about this example. That can only be a reference back to 120, which is RM.
Miss Edwards was not challenged about that example in cross-examination.
So you're telling us that sentence is completely wrong?
Yes, I'm telling you that.
Well, it's very fair of you to acknowledge that, but then what on earth is the judge talking about?
The judge is talking about the example D, the 15th example in the defendant's disclosure, which is in paragraph 164. Because that was a call to Kaylee Edwards, and it was a call that she was cross-examined on.
Sorry, that was, I wasn't keeping up. That was the, which one?
It's in paragraph
15th, did you say?
It's the 15th, 164.
Yes, that's it. Yeah.
That can be the only example, because that was the only one that Miss Edwards was taken to. Miss Edwards is a PETSURE ambassador. She is not.
But how does that fit with the second sentence? The claimant says the email had caused the customer to think she had a policy with PETSURE.
That must relate to 120. That first sentence, 121, is not correct. And my interpretation is that 122 can only be talking about the example that Miss Edwards was challenged on in cross-examination. Because 122 is talking about calls to PETSURE, not calls to VETSURE.
What you're saying is that 121 is hopelessly confused.
It's talking about two different instances. I perhaps wouldn't put it in those terms. But that's the.
Well,
that's
it's talking about two instances, but it's actually interleaving them.
The third two sentences. Sorry, all the sentences apart from the first sentence make perfect sense in relation to the first instance paragraph.
Do they? I'm just wondering about that now. I hadn't wondered about it before. It says, the claimant says that the email had caused the customer to think that she had a policy with PETSURE. I thought the hypothesis a moment ago was that the customer had received something from PETSURE and that had prompted her to think, oh, well, I better get in contact with VETSURE.
That's the claimant's submission. That's what the claimant was saying.
I see. Yes.
So he's disagreed with that submission. So I accept that it's could be clearer.
Yes, that's it.
But 122 cannot be talking about 120 because that is talking about calls to PETSURE rather than calls to VETSURE, of which 120 is an example.
In 122, it's clear from this example and others that the staff at PETSURE sometimes mentioned the claimant to callers who were uncertain or mistaken.
Because that can't be right, because this was a call with VETSURE.
That's what I'm saying. 122 cannot be talking about 120.
So the first sentence of 121 refers to 164, and 122 probably refers to 164.
Exactly, yes.
And it is a bit odd that the second and third sentences of 121 refer to 120.
It's a bit odd, yes.
Yes, I see.
It's perhaps something that the parties could have picked up in the draft judgment, but they didn't.
Well, it's also fair to say it's the sort of main sort of problem which arises when the judge is only looking at written submissions.
Yes.
It shouldn't happen. Still shouldn't happen, but perhaps it's more likely to happen.
In our deal, well, it shouldn't. But I think the point in 122 is still a good one that he's making. It may be in the wrong place, but it's still a good one. And picking up on 122, the example in question, so there was a call to Kelly Edwards at PETSURE, and she did mention VETSURE on that call. The caller in question couldn't quite work out who her insurance was with. It wasn't PETSURE, so she mentioned VETSURE. It wasn't actually with VETSURE, but the caller did mention VETSURE. But Miss Edwards' evidence, which was the criticisms of which were not upheld by the trial judge, was that she didn't mention VETSURE more than anybody else. And so that didn't support the claimant's case, which was that people are always mentioning VETSURE. when they call PETSURE.
Yeah.
So, and then next, the paragraph 123, the judgment, BW, and the transcript of the call in question is at page 302 of the supplemental bundle. This is VETSURE initiating the call. So this is not VW calling VETSURE, this is VETSURE calling VW. And you can see that she has left a voicemail with VETSURE. And she has asked, yeah, so do you have a quote or do you want a quote? I do have a quote, I think I do. Oh no, I don't. Wait a minute, I'm confused now. So she's already discombobulated by this person giving her a call. And she's obviously been looking for insurance quotes for insurance for her pet insurance. And she's plainly not confused as to whether VETSURE and PETSURE are the same or economically linked. She is just checking that it's VETSURE, or whether it is VETSURE or PETSURE who has called her. That's all that's going on. My learned friend says the judge should have noted that the recipient of the call did not distinguish on the basis that the marks were conceptually different. My submission, that's an absurd requirement of the judge in this case. All he reasonably do is look at that, see it's a call from VETSURE, and she's just checking who's calling her. It's as simple as that. The next one my learned friend took me to was MBART events, which I've already taken your lordships to. Then there was BT, which is the judgment paragraph 136. And the documents start on page 310 of the supplemental bundle. So this is one of two instances in the papers for this appeal where claim forms have been sent to the wrong insurer. And in this case, a claim form has been filled, a VETSURE claim form has been filled out, but actually the insurance policy is with PETSURE. And there is no explanation for why the error occurred, as the judge said. There's nothing at all from the customer itself, even on the face of these documents, so the actual holder of the insurance. And we don't know how the customer obtained the claim form. We can see from the face of it, so the claim form itself is on page 313. You can see on the face of it that it was filled out on paper. But there could have been lots of these forms available at the vet practice, in which case the customer was just handed one and plausibly did not pay any attention to the VETSURE name. It was a simple form filling exercise rather than a purchasing decision. At this stage, all they're doing is just doing something that the vet requires them to do in order to finance the treatment. And the customer could also just have forgotten who their insurance policy was with, as we've just discussed. The other point relevant to this example is that the claimant disclosed examples of vet practices making mistakes as to claim forms other than between VETSURE and PETSURE. We referred to them in our closing submissions, and the reference for that is paragraph 85, tab 12 of the supplemental bundle, page 278. And that shows that this type of mistake was not occurring just as between PETSURE and VETSURE. And it feeds into my general point that this shows, this goes to the general sea of evidence to which the judge was exposed. exposed, and it shows the limitation of island hopping, as we have been doing in this case, on this appeal. My lords, the next was paragraph 141 of the judgment, SJ, and the relevant documents start at page 317 of the supplemental bundle. This was another claim form mistake, and so many of the same submissions I've just made apply to this as well. But I ask you to go to the transcript, and on page 318, so this is a conversation between the Vets for Pets Vets for Pets are the vet, the telephone operator, and a VETSURE telephone operator. And there is a conversation on 318. Yes, in fact, we can pick it up about four utterances from the top. See, the VETSURE telephone operator. Yeah, that's okay. That's no problem. Do you know if the form was provided by the policyholder, or was it that you guys have printed it for them? So the VETSURE operator is trying to get to how this mistake was made. If I can skip down all the way to the bottom, so 8 lines up. See the Vets for Pets telephone operator. So it could be, oh, that's weird. So on our reception list of when it was handed in, we've written PETSURE. Then we've got the form for VETSURE. So I've got a feeling that we might have done it. When we've Googled PETSURE, it possibly came up with VETSURE first, and they've just gone with the first one that came. The submission I make on that is that it shows the level of attention when obtaining a pet insurance form is not very high at all. And so not the same as when a customer is purchasing pet insurance, a pet insurance policy.
Is it your submission that the purchase of the insurance is the only relevant point for consideration?
I don't think I need to go as far as that. What I would say is that it's not relevant, the obtaining selection, filling out of the claim.
Claiming on insurance is just as important as when you take it out.
Not for the insurer. Sorry, insured, my lord. Not for the insured.
Well, when you take out insurance, you pay a premium, and when you make a claim, you expect to get some money back.
Yeah, but you get there in the end. All you do when you make a claim, is like, right, I need to get my money back. I'll make a claim. But you're not actually distinguishing between undertakings of providing pet insurance.
You want to make a claim against the right party because you won't get paid out otherwise.
Yeah, but then it's found out, and there is no consequence to a mistake in that respect.
So your submission is that nothing other than the point of purchase is relevant. Is that the submission?
As I say, my lord, that's not as far as I would go, but I would say that this is not a relevant circumstance of confusion, of mistake. And that is supported by what I just referred to, was that mistakes were made as between different pet insurance companies and claim forms, and what's happening at vet practices. And moreover, in this specific example, go to page 322 of the supplemental bundle. So this is what looks like an invoice or a statement of account for this customer that's relevant to this claim. And you'll see in the top left-hand corner, it's addressed to Pet Plan, Great West House, Great West Road, Great West Essex. Pet Plan, of course, is the market leader for pet insurance. So there's another mistake being made as between pet insurance companies in this same instance of the claim. that shows that there's nothing special about the mistake as between VETSURE and PETSURE in this instance. My lords, then paragraph 142 of the judgment and pages 325 of the supplemental bundle. This is an example of a customer having a PETSURE policy and they mistakenly call VETSURE to correct something on the policy. In my submission, this is an example of a customer phoning the wrong number, as she said, expressly. So it's on the second lower hole punch. Hang on, I'm phoning the wrong number, I'm sorry. Not only do I not know that my dog is spayed, is not spayed, I don't know who she is insured with.
But is that not consistent with confusion? I mean, why is she phoning the wrong number?
Because she can't remember who she's insured with. She can't remember who her pet insurance is with.
So why is she calling VETSURE?
Because she's calling a...
Can't be a random choice, can it?
Well, it is a descriptive name. I keep coming back to this. It is, as the judge has found, saying, I've got...
So the supposition is the person has done a directory inquiry for what? Vet insurance?
Or pet insurance.
And that's led them to call VETSURE.
Yes, my lord. That's a perfectly plausible explanation.
But what she
as to
says,
why she's made the mistake here.
What she says is, you're VETSURE, and I think I've just insured her with PETSURE. Now that's consistent with her thinking, I need the number for my insurer, and getting muddled between PETSURE and VETSURE, and therefore phoning the number for VETSURE.
Well, it's also consistent with her just not remembering who her insurance is with. And she herself has recognised the error that she has made during the course of this call. And she's also made a mistake. She's also recognised that she's made a mistake as to whether her dog is spayed or not. So this, again, is indicative of the level of attention in these types of examples. As the judge
So you're saying this is an atypical level of attention?
Well, it's not... Again, it's not a circumstance that is probative of the question of likelihood of confusion.
Well, what's atypical about this instance?
Because she's not paying attention. She's not paying attention to the extent that she can't.
Why is she any more confused than any average human being with a pet?
She's getting whether her pet is spayed or not wrong.
Yes.
That's the type of thing.
Sorry, that's the kind of mistake that pet owners can make all the time. What's atypical about it?
Well, we don't know that, my lord. I mean, that is not something that I can agree or disagree with, because there's no evidence on that.
That entry caller, it's the SURE that got me going. Your VETSURE, and I think I've just insured it with PETSURE, is quite hard for you to deal with. I mean, you may say it's just one instance, but
my lord,
she's got in mind SURE, and then she's found the number for the wrong SURE.
This is why I say this actually supports our case. This explanation here, we do have insight as to why she has made this mistake. She has specifically identified part of the mark, the common part of the mark and sign, as SURE. That is why she is saying, taking it at face value, that is why she has made the mistake that she has made in this call. It's not because PETSURE as a whole is one letter different from VETSURE. It's because she's seen the SURE element of it. And it was the claimant's own evidence in the case that SURE would be perceived by the average consumer as indicative of insurance, describing insurance. So it's purely descriptive. And that is what has caused the mistake here. So it does not support my learned friend's case. And it supports the judge's reasoning, because he has said, this is why people are making mistakes, because the marks are descriptive. And this is a mistake that, on its face of it, is made purely on the basis of a purely descriptive element of it, which is the same in each of the mark and sign. penultimately, there is the instance paragraph 152 of the judgment, BP. So this is one of the instances from the defendant's disclosure, and the relevant documents start on page 328, supplemented on there. But they're in reverse order. So the actual first, this is a web chat on the PETSURE website, and the first post is just a question mark, C-O-T-P-A. And then PETSURE asks them, how can we help you, and so on. And this customer is trying to get a pet health plan. And just so your lordships are clear on the detail of that, pet health plan is not an insurance policy. It's a plan for preventative treatment of the pets that's taken by a standing order.
So that's your injections or your flea treatment or whatever it is.
Exactly. Yeah, vaccinations and flea treatment. So.
Yeah.
And that is something that VETSURE provides, but PETSURE does not provide. At least didn't at that time. And you can see that he says at the top of page 328, thank you, Lucy, when it's pointed out to him that PETSURE that he's contacted the wrong person. It appears that I was having one of those moments. Thank you for replying. So, 2 points. First of all, this is a different field. This is provision of pet health plans, not pet insurance. And secondly, again, I point to the level of attention that is being held at this point, at this type of communication. And that's why it's not prohibited. And then finally, the instance at 165, the judgment. So this is the 60 in the defendant's disclosure, which is PG. And this is where the judge finds, it appears in this case that there was some confusion. It is, and that is a conclusion that was open to the judge on the evidence, and we don't challenge that. But that doesn't mean that he was then bound to find a likelihood of confusion, as the authorities show. So in conclusion, the judge followed the approach of the authorities, the principled approach, took all the evidence into account, and he came to the conclusion that there was no likelihood of confusion. That's a multifactorial evaluation that was open to all the evidence, and that's why this appeal should be dismissed.
Thank you very much. Mr. Brown, back to you.
A few very short points in reply. My Lord's going right back to ground 2. My learned friend said these were portmanteau terms, and we agree, but that is why it is all the more important to understand what the understanding was of the portmanteau term, not the elements of it. We say point against him, not point in favour. My Lord Justice Phillips raised an example of insurance in terms of vets when he was trying to explain what that portmanteau conception might be in the judgment. The fact that we are having a debate about it is, in my submission, an indication that the judge had not done what he should have done, which is to clearly set out what he thought the answer was. My lords will have to come to their own conclusion as to what the answer is, but I would ask that when doing so, you bear in mind those other paragraphs in the judgment that deal with the issue of the meaning of the mark, because it isn't only in section 5.2 that there is commentary, and in my submission, when you look at the other sections, it's clear that he is not thinking in the terms that my Lord Justice Phillips indicated, but in fact that it is indeed, as we have suggested, that it is a reference to pet insurance. In particular, can I point you to paragraph 93, because there he's talking about the VETSURE mark, and in the middle of it he says the mark indicates that it is a service relating to vets. But also in what he'd said, and I'm just picking a couple of examples here, but they are present elsewhere in the judgment, but in particular 84 and 85, he's saying they are descriptive of the services. Well, the services in question are pet insurance services. 85, he talks about the market. It's the market for pet insurance services, so not the kind of insurance or service that my Lord Justice Phillips was talking about. Third point, my learned friend got himself into some difficulty in explaining what his position was on this idea of conceptual counteraction. My Lord Justice Arnold knows that it's a well-established concept. The case, I think, the leading case is a Court of Justice case, Picasso-Picaro, that talks about it, but there's others, Bass, Pash. And one of the points they make there is that in order for that conceptual counteraction to apply, the consumer must immediately grasp the conceptual meaning of the marks. Now, because of that authority, my learned friend gets himself into difficulties because he's caught coming or going. He's backed away from the idea that in the judgment, the judge is talking about conceptual counteraction because he knows that at least Lord Justice Arnold is familiar with the requirement that it be immediately grasped. And he wants to be able to justify the failure to say what the portmanteau means by saying that there's only a kind of general description, but then he runs slamming straight into the problem with approach that talks about conceptual counteraction, but then you don't have that immediate grasp. So that's where he gets into that trouble, tries to dig himself out. The truth is that at first instance he said there was conceptual counteraction, and that's how the judge has taken him. We say that can't be sustained, and you have my suspicions on that. Finally, just on the very last point that my learned friend Mr. Aikins was addressing you on, a few small observations on the ground 14 evidence. The first is that my Lord Justice Arnold said, well, it's not always clear what exactly the judge thought of each of these instances, and paragraph 170 brings that to the fore, because there the judge talks about there being confusion in a small number of instances. My learned friend says there's only one. It's the one that's referred to at paragraph 165. I would say to you, it's better to understand it as being only one where he is explicit when dealing with the specific instance that he considers it to be confusion. But you can tell from 170 that he thinks others are. We just don't know which ones. And of course, as you know, as I went through those paragraphs, in some cases, his paragraph dealing with it is just a description of what's happening as he understands it in the particular instance in question. He gives no conclusion. That's part of the problem that we're labouring under. But we do say that that paragraph makes it clear ultimately he thinks it's a quantitative question. Is there enough, he asks. I do say that at least in relation to the propositions that are central to your analysis of whether there's a likelihood of confusion, you should be using the evidence to test it. It doesn't require you to test every proposition, but it does require you to test the ones that are pivotal. Then on the specifics, my lords, just a very, very short couple of points. You were asked to look at the example on page 301 of the supplemental bundle. That's the very first example that was dealt with by both the judge and myself. If you look at that, there was a debate that happened between my lords and my learned friend as to what could really be understood about what was going on, and it was suggested, well, look, I think it may have been my Lord Justice Newey said, well, maybe they understand we're in the concept of pet insurance here, and that's where they're talking about. That's how they've got here. We do say you have to factor in what is said at 301. You don't ask, okay, can I just check that you are definitely VETSURE, not PETSURE, if all that's happening here is that you are referencing the descriptive discussion of pet insurance in general. You've got yourself confused as to who you're dealing with. It's not actual confusion because all that we have here is uncertainty. And uncertainty isn't enough. I'm prepared to acknowledge that for an example like this. I hope I did in my submission. Does it show a likelihood of confusion? Absolutely. My lord, there was then a discussion about what exactly a judge was saying across 121 to 123. I think we can agree on this. It's not very clear and the judge has gone wrong somewhere. We say that that is grist to our mill. He's misunderstood, if not what's happening in the particular example, then he's misunderstood what's happening in the cross-examination. He's expressed himself in that way. You were then taken to 310 of the supplemental bundle. The point only that I wanted to draw your attention to here is that you may recall in my opening submissions to you, I had particularly drawn your attention to the analysis of the email that's at the bottom of page 310 that goes over the page, because there you've got someone emailing a VETSURE email address referencing PETSURE. my learned friend didn't even touch upon that, or why it is that the judge, when he looks at it, hasn't queried how it is that that's arising and the propositions that it would have allowed him to test. So we say that skipping over is telling. 318, my lords. You were taken to this at some length, and there was a discussion about it, but my learned friend began by saying, start 4 lines down. Yeah, that's okay, no problem. Do you know if the form was provided by the policyholder? My lords, we say you've really got to start at the top of the page, because there you have the Vets for Pets telephone operator going, possibly, we've got it as my PETSURE, whereas, VETSURE and PETSURE. We do suggest that that is helpful to you in understanding what has gone on later on. There's only one reason to say, VETSURE and PETSURE, is because they're knowing they've spotted where they've gone wrong. Lastly, my lords, discussion of page 325 of the supplemental bundle. Really, what I ask here is that you bear in mind that on appeal, the point that I have to begin with is to show you that the judge has gone wrong in his analysis of the evidence. And my lords are as capable as I am of looking at what's said on pages 325 and 326. My lords discussed it with my learned friend, and what it indicated, I think, my Lord Justice Newey, in a bit that no doubt I will seize upon in discussion later on, said that you're going to have some difficulty explaining about that line at the end there, your VETSURE, and I think I've just insured with PETSURE, so that's what's happened. But for my present purposes, the point I draw to your attention is that the judge, in describing this, is doing so at paragraph 142, and he says there, it's not clear that the caller was confused. My lords, I do say there is no world in which that can be the way to describe what has gone on here. My lords, if you would give me one moment just to check. My lords, unless there was anything that was raised by my learned friend's submissions you wanted me to respond to.
No, I don't think there's anything. So thank you very much, Mr. Randworth. Thank you very much, all of you. We won't, of course, be giving judgment here and now. In accordance with the normal practice, you'll be supplied with the judgment and draft for you to correct our typing and English, but not to re-argue the case. I know that you will have well in mind the importance that is attached to the embargo. If, come the time that you receive the draft, you think that there is anybody who ought to see the judgment who we don't already know about, can you please obtain permission for that? Again, when you receive the draft, we'd be grateful if you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have short written submissions, and we would expect to rule on the points in the order that we make. But thank you again for your submissions.
Court rises.